Okay. Just make sure we can manipulate this. Yes. So first off, a disclaimer. As most graduates of the MJ program, I am not an attorney, so nothing I say should ever be considered legal advice. But, you know, the Dobbs decision has significant legal and operational implications for businesses and individuals on multiple levels, and many of which remain uncertain. So if a question comes up, make sure you are talking to your attorney, and make sure your CEO, your board of directors, the people who make the decisions, have a couch in their office where the attorney can sleep, because this is a complicated issue. Let's see. So I have an agenda here, and I'm going to try and follow it. And I want to point out a few things. It's not my intention to submit all of you to death by PowerPoint, but by way of explanation, the PowerPoint is here to make sure I don't ramble. This is a very broad topic with a lot of moving parts. And I want to stay above the weeds as much as possible, because we have a lot to cover, even if we're only going to scratch the surface. Professor Matambanazzo mentioned that she's been sending me all kinds of articles, and I wanted to publicly thank her for that information, because a lot of what she sent is incorporated herein. Two additional points. My intent for this presentation is to be neither pro or anti-abortion, but rather take an objective look as much as possible. I can't say that I'm 100% objective, to look at the ever-changing landscape that we're now in. If I don't succeed, well, that's on me, and apologies in advance. The content is not meant to be comprehensive or all-inclusive. The fact is, there's just too much happening too quickly for it to be. I kept checking the internet today for the Texas federal court judge's decision on the medical abortion drug, and because it was due like last week, and so far nothing. But it's that quick that things are changing, and so the sands are shifting beneath our feet. So we're going to take a look at first what happened very briefly, the context regarding state responses, and then federal responses, or what the federal law states, as much as I can do that. And then we're going to take a look at what the workplace minefield looks like, danger and possible opportunities for employers and unions, because I do some mediation, so in any conflict, there's two parts. There's danger, and then there's opportunity. So we're going to talk about both of those. And then we're going to try and read the tea leaves a little bit. Is that the light at the end of the tunnel or another speeding train? And I wrote that way before all of these railroad accidents, but it seems very apropos. But first, I want to, just by a show of hands, ask some questions, a question or two of you. How many people here grew up or were exposed to romper room? Or am I showing my age? Okay. I can't see everyone on the side of the screen, but so for those of you who are unfamiliar with romper room, it started in the 50s, and in 1958, it was one of the hosts of the Arizona edition, and this was a nationally syndicated program, children's television show, and her name was Miss Sherry. And the show started off with the Pledge of Allegiance and lessons and songs and games for kids. She would serve milk and cookies to the children on the show with a very simple prayer: God is great, God is good, let us thank him for our food, amen. They had a Mr. Doobie, which was an oversized bumblebee who taught the children proper deportment, and Mr. Don't Be, who demonstrated what children shouldn't do. And although she had 4 children at the time, she found herself pregnant. And the problem was she had, in order to combat the symptoms from morning sickness, her husband, who had been traveling in Europe and Germany, picked up some thalidomide. And thalidomide was a drug that German manufacturers put out that hadn't been properly vetted. And it was resulting in a lot of fetal death and disfigurement, and with death shortly thereafter, but not in all cases, sometimes just disfigurement. And so her and her husband talked about it. They decided that the abortion was the way to go. Her doctor definitely did. Her doctor showed her some pictures of the results of thalidomide. And she had to go, I thought this was interesting, before she had to petition a 3-man board of doctors, but it was 3 men, for permission. And she was, at some point, she said, you know, other women have taken thalidomide. Other women have to know about what can happen. I'm just lucky that my doctor is helping me. So it was supposed to be, and it was, an anonymous article in the Arizona Republic, and she was identified only as a Phoenix housewife. And the panel of doctors did, in fact, approve the abortion, but a hospital administrator canceled it, concerned about the legality of the procedure. And this was 1962, a time when abortion was not only illegal, but unthinkable. And so they decided that they were going to have to go to Sweden. But in between, word got out as to who this Phoenix housewife was. The letters, the hate mail flooded her mailbox, and they had to, the phone calls and the threats came in. It got so bad, the FBI had to station agents at her house. And so they did what I think we're going to see a number of people do in the future. They went to Sweden, where the procedure was acceptable. She had to be examined by the doctors and interviewed by a psychiatrist. And that board granted her request for legal abortion to protect her mental health. That's a criteria we have in this country right now, but not in all states. You know, she told the reporters that Sweden regarded abortion in a realistic manner, not as a religious or legal issue, but as a medical matter. Anti-abortion laws in the US were outdated, and she hoped that would change. Now, again, this is 1962, about 10 years before, 10 or 13 years, 10 or 12 years before Roe. But she couldn't believe that the conversation hasn't changed that much since. Now, I'm looking here for a particular quote. Oh, so what happened? Well, it affected her workplace and her husband's workplace. Her husband was a teacher at Arcadia High School in Phoenix, and he didn't lose his job, but he lost his teaching assistant, who was Catholic and did not believe in abortion, or if that abortion was right, but they never replaced her either. At some point, Miss Sherry was labeled, quote, by the studio, unfit to work with children. That was by a local TV official. And she lost that job. She found other work eventually. After Roe versus Wade was issued, she met the 26-year-old attorney from Texas who argued the case, a Sarah Weddington, who told her, your case made my arguments so much easier. So what Professor Matambanadze was saying is very much on point here, because it takes a lot of courage. But that was life in America before Roe. So with that, let's continue. So as we all know, after 50 years, the Supreme Court's majority opinion in Dobbs versus Jackson upheld the Mississippi abortion law, overturning Roe. And now it doesn't mean that there is a national restriction on the access to abortion. It's gone back to the states. So it's like a lot of other laws that we have where things are different in different states. But it's important to know that there is no federal ban on abortion. But it's opened the floodgates, and the states are no longer limited in what kinds of abortion restrictions they can pass. So some states have legal protections in place ensuring the legality of abortion, and other states have banned or severely restricted abortion. And this begs the question, which we'll explore further on. Is it legal to travel out of state, or I would add even out of country, to get an abortion regardless of your state of residence? And so stay tuned, because this has yet to be tested. That legal battle will happen. So there's been an impact and challenges so far with the federal and state employment laws. You see them listed there. But in the moment, all of these can be problematic for the employer, and in some cases, the union as well. And we're going to try and address those as much as we can. So this is a general overview of the state responses, and you can see there, and if you do the addition, there are 47 out of the 50 states that have some kind of restriction control on when an abortion can take place, if at all. And now several states have implemented trigger laws, which impose categorical bans. That was it. Missouri was studying a bit to take a look at whether or not to enforce abortion restrictions through lawsuits if it occurred outside the state. So now we have one state putting out laws and thinking about putting out laws and regulations to control what happens in another state. Any guesses as to how that's going to go? Probably directly to the Supreme Court. Now, on the other side of the coin, 20 Democratic governors created the Reproductive Freedom Alliance. And it's interesting, I was just checking, about a third to a half are female governors. And they're trying to leverage and share resources. And Tennessee has an interesting situation. Governor Lee there proposed $100 million for crisis pregnancy centers. And, it's one thing to say you can't have an abortion, you have to have the child, but then what? Especially if the person is in a lower socioeconomic situation or has other needs. Well, he's proposed that this $100 million go to meet those needs. And that's the only thing I was able to find from a state that has very strict abortion restrictions, where there was a hand that was, a hand out to lift people up who were in this situation and at least address the consequences of the law. And then, of course, there's Texas. Texas has its law is right there to knowingly engage in conduct. And that's an interesting term because, what does that mean? If I lend somebody money and I know that it's for an abortion, am I now aiding or abetting? Or if I drive somebody, if I'm an Uber driver and I drive a young lady to a abortion clinic, a Planned Parenthood center perhaps, am I now aiding and abetting? It raises all kinds of questions. Texas has on the books a $10,000 bounty for turning these people in. So they've got citizens turning in other citizens. Kind of smacks a little bit of 1984. An individual in Texas can block a federal program providing birth control to teens based on their religious beliefs. So it's one thing to say don't get pregnant to a teen, but now you're taking birth control away from them. So it's the thought police are not far behind. And of course, and this is true in a lot of states, ER doctors must weigh equally the life of the fetus and its mother, which is not always the case in every state. And that takes us to a little discussion on, and I'm going to try and pronounce these correctly, mifepristone and misoprostol, which is also, those are the two drugs used in medical abortions. And a group called the Alliance Defending Freedom, before the U.S. Fifth Circuit District Judge Matthew Kaczmarek, a little bit easier to pronounce than the drugs themselves. He's hearing the case, and his decision is expected any day now. Then the Alliance Defending Freedom, their allegations is that the authorization from the FDA is flawed. They're alleging that the FDA erred using approval process for drugs treating illness because pregnancy is not an illness, but a condition. And if upheld, the FDA would need to rescind the drug approval and restart the approval process again, minimal 2 years, maybe longer. And when it comes to manufacturers, they may not even be able to ship the drug to states where the abortion is legal. And providers will still be able to use the second drug, though, misoprostol. And although it's safe, it's only about 80% effective and has more severe side effects. But Texas is not Las Vegas, where things, where what happens there stays there. So if this happens, it's going to ignite a national flame covering nationwide distribution and use. I could not but help think, is birth control next on the hit list? And now there have been challenges to any restrictions by providers and manufacturers in West Virginia and North Carolina. And the United States Postal Service has said it's okay to deliver if the sender intends it for lawful use. But a number of Republican attorneys general disagree. When I saw that it's okay to send it through the mail if if the sender intends it for lawful use, it did make me think about marijuana. Although the federal government hasn't recognized that, some states have. So how's that going to figure in? And as recent as last Friday, Walgreens said it will not sell in 20 states that warned of legal consequences. So picture's worth 1,000 words. This is what's happening right now. You can see by the colors where abortion is available. There are some limits, extreme limits, and it's banned in its entirety. Now, it's interesting to note that states banning abortion rights have over decades also intentionally constructed an economic policy architecture, if you will, defined by weak labor standards, underfunded and purposefully dysfunctional public services, and high levels of incarceration. States with abortion restrictions or total bans have on average lower minimum wage. It's usually $8.17 compared with an average of $11.92 in abortion protected states. Unionization levels are about half as high as those in abortion protected states. Only 3 in 10 unemployed people receive unemployment insurance, which means that the other 7 have exhausted their unemployment insurance or can't qualify for some reason, compared with 42% in other states. And there's lower rates of Medicaid expansion, people using Medicaid, and the incarceration rate's about 1.5 times that of the abortion protected states. So what's federal law got to say about this, and what kind of protections do the federal law give? Well, the Pregnancy Discrimination Act, or PDA, as we know, prohibits employment discrimination on the basis of pregnancy, childbirth, or related medical conditions. Now, in construing the PDA's reference to childbirth, the courts, federal courts at least around the country, have held the PDA prevents employers from taking adverse employment actions, including firing, demotion, or preventing the opportunity for advancement because of an employee's decision to have an abortion, as well as an employee's contemplation of an abortion. So the PDA also prohibits adverse employment actions based upon an employee's decision not to have an abortion. So, for example, an employer would violate the PDA if it pressured an employee to have or not have an abortion in order to keep her job or be considered for a promotion. I did wonder, though, well, what if they're putting pressure on the boyfriend or the other party involved in this? Does that, like some EEO indirect discrimination, also count? Because contemplation can mean a lot of things. I was not able to find any rulings addressing this question at this time, but it doesn't mean that the risk for an employer regarding partners who are also employees is not zero. You know, people in the workplace, they think the workplace is a debating society, and they just love to get their noses in other people's business. So I think eventually that question is going to come out. There may also be, in addition to what I've said so far, First Amendment free speech implications in this matter, depending if the employer is public or private, and the context of the speech or any prohibitions thereof. And we're going to talk more about what can and cannot be said in the workplace. So HIPAA, and we've got a lot of slides on HIPAA and this stuff. It's not exactly page turners, but if you're working for an employer in HR right now, this is what you need to be banging the drum on for these people. The first is PHI, or personal health information. And personal health information providers, they need to start evaluating what information they're going to start giving. Let's see. Yeah, HIPAA permits disclosure of PHI if the provider reasonably believes the individual is a victim of abuse or neglect, if the disclosure is required by law, and if it complies with and is limited to the relevant requirements of the law. You know, HIPAA also permits disclosure of PHI by a covered entity if it's consistent with applicable law and standards of ethical conduct, and if the covered entity believes in good faith. I deal with good faith in labor management relations all the time as an arbitrator. I got to tell you, that's grievance language right there. But in good faith, that disclosure is necessary to avert a serious threat to health or safety of a person or the public. Just like Miss Sherry's would have fit, I believe, into this category. Or the individual is not able to agree to the disclosure because of their incapacity, and a law enforcement official or other public official authorized to receive the report, or the PHI, represents that it's not intended to be used against the individual, and an immediate enforcement activity that depends upon the disclosure would be adversely affected by waiting until the individual is able to agree to the disclosure. I have no background in criminal law, so I have no idea what all of that means, but it's something that if you're in HR, you probably need to be talking to your attorney and saying, should we be doing something new? Now, continuing with it, providers must promptly inform the individual of the disclosure unless the provider, in exercising professional judgment, believes informing the individual would place the individual at risk or serious harm, or if the provider would be informing the individual's parent or legal representative, and the provider reasonably believes the parent or legal representative is responsible for the abuse or neglect, and then informing them would not be in the best interest of the at-risk individual. HIPAA also permits disclosure by a covered entity when it's consistent with law, like I just said. So keep that in mind. And continuing more with HIPAA, there's a lot here, folks. A healthcare provider in a state which outlaws abortion may report a patient to authorities if the provider believes that an individual might be harmed. But they need to tread very carefully here, because the Health and Human Services guidance does not address the ability to make disclosures about victims of abuse, neglect, or domestic violence. Pretty much HHS says, according to major professional societies, including the American Medical Association and the American College of Obstetricians and Gynecologists, it would be inconsistent with professional standards of ethical conduct to make such disclosure of PHI to law enforcement or others regarding an individual's interest, intent, or prior experience with reproductive health care. So healthcare providers are going to need to evaluate whether they're acting in accordance with standards of ethical conduct before disclosing any PHI of an abortion patient under those circumstances. And good news is, lastly on HIPAA, HHS also gave more guidance on its website addressing privacy and security risks associated with an individual's disclosure of PHI using a personal cell phone or tablet. So think about apps here, noting in its alert that patients have expressed concerns related to use of fertility trackers and other apps. More often than not, the information is not subject to HIPAA protection, and users should proceed with caution. So when it comes to privacy, employers need to be thinking about providing any benefits or stipends while protecting employees' privacy, not violating HIPAA, and where applicable, not running afoul of so-called aiding and abetting legislation. To that end, some companies are requiring employees provide only travel receipts and not documentation of the reason, abortion, to qualify for a benefit, reimbursement, or stipend. It's literally don't ask, don't tell. There are concerns, like I said, about apps such as Uber. So if I fly to a different state and I go from the airport or the train station or the bus station to the site for the abortion, and I take an Uber, as far as I can read this, that's discoverable, and if they're looking into a criminal activity. And so there may be an argument against that, but it appears that that's a real concern. Of course, without any verification, there's always a potential for abuse regarding the don't ask, don't tell portion of this, because somebody could say, well, I'm using it to go for personal travel, and therefore I should get the reimbursement, or I'm going for to take care of a bunion, and in fact they're using it for personal vacation or some other reason that's not affiliated with that. So what about your workplace if you're in an anti-abortion state? Well, and you're a healthcare provider. Well, healthcare providers, there's potentially complex reporting and investigation requirements, including if a patient comes to a hospital after a potential miscarriage or with post-abortion complications. Questions will also arise regarding what impact, if any, procedures performed by a provider in a permissive state will have on a provider's license in a restrictive state. So entities are going to need to consider the requirements of state licensing boards and accreditation entities. To put it bluntly, if I'm working in a state other than Texas, but I have a license to practice in Texas, and the medical board in Texas decides that, hey, Bob has been performing abortions up in Michigan, guess what? I might have my license pulled in Texas. So the Dobbs decision will require residency programs to determine how, medical residency programs to determine how they can provide training to residents, in particular OBGYN programs, where they are required to include abortion training as part of the curriculum. And that's as required by the Accreditation Council for the Graduate Medical Education Association, and for residents who may practice throughout the U.S. given state law restrictions. In addition, attention is going to have to be given to providers' policies and procedures, which will need to be tailored to comply with each state's abortion law, including in the areas of documentation, reporting requirements, medical versus surgical abortions, determination of what qualifies as a medical emergency, treatment of patients from other states, and the prescribing and mailing of, I'm going to try and pronounce it again, mifepristone across state lines. Now, here's how, to the extent this goes. A perinatal pathologist is someone who does research on the causes of miscarriage or stillbirth. And they do that by examining tissue samples from miscarriages, stillbirths, and what have you. And the problem is, these folks are worried about what their future holds. Police and prosecuting attorneys have always been interested in investigating pregnancy loss, acting on the suspicion that some miscarriages and stillbirths are intentionally caused by or otherwise the fault of the mother. Particularly in substance abuse cases between 1973 and 2020, so almost for the entire period of Roe, more than 17,000 cases of arrest detentions and I'm quoting now from the Pregnancy Justice Group, quote, equivalent deprivations of personal liberty, unquote, of pregnant people occurred. In a post-Roe era, legal experts worry similar cases may gain more traction going forward. For our friends, the perinatal pathologists, they're trying to address these pressing concerns, including when a pathologist can identify evidence of an abortion and when they cannot, and how to properly dispose of tissues. This group of scientists are meeting regularly to develop new guidelines for their workplace. But for the moment, they're very much in the middle, anxiously waiting for the other shoe to drop. So let's talk about directors, officers, and the boards, the people who should be accountable. For many of these folks, leadership in crafting their company's response to Dobbs may have material effects on their business for years to come. While boards may be able to choose how visibly they engage certain social issues, few, if any, companies will be able to remain silent. Translation, the ostrich approach will not work. And the interesting thing about the ostrich approach is your head may be in the sand, but what other parts of your body does that leave exposed? So the first challenges many boards will face are the need to undertake a critical assessment of the company's culture and priorities and to craft clear internal and external messaging of the company's position. I have to tell you that when I read that and when I wrote it down here on my notes for the slide, I laughed because my experience is that denial is a very powerful opiate, and that sentence describes a responsibility that I have not always seen on the management side of the table when I was representing the management side. On an issue such as abortion rights, corporate culture will likely not be singular or uniform, so it's going to be all over the place. Nevertheless, directors and officers should approach the issue with the same transparent and well-documented deliberative process as any other board-level decision. I'll refer back to my previous remark. This includes hearing from all the company's stakeholders, which is always a good idea. Investors, employees, managers, vendors, customers, and where applicable, the unions, which will inform the company's decision and position and hopefully make it a better decision. Directors and officers should also assess the potential financial repercussions of their position and how it's messaged, because these could include changes in healthcare costs, hiring and retention challenges, and even customer boycotts. You may recall, some of you may or may not know, but dolphin safe tuna. How did that start? It started when a little elementary school child, I believe it was a young lady, sent a letter to Starkist, I think it was, saying, I think it's terrible that you're using all these nets and all these dolphins are dying. And I'm not going to eat any more tuna fish if that's the case. They looked at that, and that started a flurry of letters. And it was all coming from kids, but they said, those kids are going to buy our product at some point. So we need to be listening to them. And that's why today you'll see on your can of tuna fish, it should say dolphin safe. So now we get to talk about white collar crimes, because state laws criminalizing abortion may give rise to investigations, prosecutions, and corporate criminal liability. Organizations and individuals will need to understand potential penalties, noting that criminal fines are typically not insurable. Private sector also needs to evaluate how the absence of Fifth Amendment privileges for corporations should inform their policies and take into consideration the crime fraud exception to attorney-client privilege. Continuing with white-collar crimes, the act of production doctrine generally does not apply to business entities. And this means that in most instances, companies will be compelled to produce potentially incriminating documents in or subject to their possession, custody, or control surrounding corporate programs aimed at facilitating out-of-state health care to a state where abortion is legal. Now, this not only jeopardizes the privacy of employees, it creates the risk that grand juries can subpoena employers to target employees merely for availing themselves of an employer-sponsored benefit program. And this is going to be critical for employers and company officials who may face criminal charges for aiding and abetting the violation of state criminal statutes prohibiting or restricting abortions to strategize about how best to protect themselves. But that could mean limiting access to abortion. Case law on jurisdictional and choice of law issues, such as which state's law is going to prevail, will continue to develop on whether incorporating or housing a principal place of business in one state gives some protection of reproductive rights, which can provide legal protection to clients. Now, additionally, we're talking now about ERISA, the Employee Retirement Income Security Act. Employer travel and lodging benefits of this type present innumerable other questions and issues, such as, is the employer benefit plan subject to ERISA? ERISA is that federal law applicable to qualifying employee benefit plans, and including employer-sponsored group health plans, you have to take into consideration, because ERISA has to comply with and work with HIPAA and the Affordable Care Act and other applicable rules and regulations, and so-called self-funded employer plans are subject to ERISA. So with some exceptions, ERISA preempts or blocks the implementation of state laws that relate to the ERISA plan. Continuing on with this, but ERISA does not preempt a state law regulating insurance companies operating in the state or preempt state criminal laws of general applicability. So you still have that aiding and abetting thing to deal with. Now, if a plan is self-insured and subject to ERISA, it may not be required to comply with state laws related to abortion services based on ERISA preemption. However, the impact of new and untested civil and/or criminal penalties is unclear. So when it comes to group health plans, what does the Dobbs decision mean for companies and the group health plans they provide for their employees? Well, depending on the states in which the employees live, abortion access under a company's group health plan may now become illegal or severely restricted. Employers will therefore have to decide whether and how to provide continued access under their plans, and these decisions will raise numerous legal and administrative issues for companies to address with their third-party administrators, payroll providers, and other service providers. And there may be some of those providers who at some point say, you know what, good luck with your plan. The risk is too much. We don't want to do business with you anymore. Thank you very much. And so there might be some changes in the wind. So travel, et cetera, under group health plans, assuming the plans are self-funded and subject to ERISA, they must also comply with other applicable rules, like I've said, HIPAA and ACA. And generally, this is limited to individuals enrolled in the employer's plan. So here's a question for you. An employer self-insures its group health plan. Are there ways the employer could provide additional benefits to help employees seeking abortions in other states where it remains legal? And the answer is most probably yes. Subject to other tax and legal requirements, companies with self-insured plans should be able to offer additional benefits under their plans to help employees obtain abortions in states where it remains legal, although some anti-abortion states are threatening to take civil and/or criminal actions against companies that do so. And for example, under IRS rules, transportation costs necessary to obtain medical care under an employer's group health plan are generally considered qualified medical expenses. So employers can consider amending their health plans to reimburse employees up to certain limits for the cost of transportation and lodging for themselves or their eligible dependents who will now be required to travel out of state for abortion services. But there are limitations, and we're going to be discussing them. So here's the next question. What if the employer's health plan is fully insured? Well, you should consult with your carrier to determine the impact of the Dobbs decision for abortion access under the plan, because these plans are subject to state insurance laws, and therefore it may not be possible to reimburse employees for the travel costs and other expenses under the plan for obtaining an abortion if the employee's state of residence bans the procedure. An employer with a fully insured plan that nevertheless wants to provide additional outside the plan benefits should discuss its options with their legal counsel. What about employee health savings plans? Well, these are also called HRAs, standing for Health Reimbursement Arrangements. An HRA, generally, they're subject to ERISA and cannot reimburse above the very minimal IRS limits, which, such as mileage, which is between 18 and 20, I think it just went up to 22 cents a mile, and lodging, which is $50 per day, unless there's two people, in which case it's $100, because the person may have a support person with them. And whatever you do with the HRAs, it should be integrated with other coverage or qualify as an accepted benefit HRA, or else it may violate certain ACA rules that prohibit lifetime annual dollar limits for certain benefits. What about employee assistance programs? Well, in certain circumstances, EAPs are exempt from the ACA, and to be an accepted benefit, the EAP cannot provide significant benefits in the nature of medical care or treatment, and cannot be coordinated with benefits under another group health plan, and cannot charge a premium for participation, and cannot require cost sharing for offered services. So the first one cannot provide significant benefits in the nature of medical care or treatment. It's highly subjective and may create risk for the employer because it's difficult to determine whether a benefit is significant. So accordingly, it may be difficult to locate a third-party vendor or provider who would administer travel and lodging benefits through an EAP. Well, what about additional benefits? If an employer decides to also offer additional benefits outside of its plan, should they establish a formal written policy? There's no clear answer at this point. A formal written policy, however, could minimize confusion as to when additional benefits will be provided by the company and also help ensure consistency in treatment amongst the employees. An employer should also consider whether the additional benefits will be limited only to abortion procedures or whether they will include a broader range of reproductive benefits, mental health benefits, or other covered health services. So the risks for offering benefits for abortion access, some states may seek, as we've discussed, criminal sanctions and or permit civil enforcement against the employer and the employees by private citizens. And although the standard is very broad, ERISA generally does not preempt state criminal laws and may not preempt all state civil laws. So be aware. And when it comes to travel and lodging benefits to employees as taxable reimbursements, that's only going to be up to a certain amount annually, as we have discussed. Some employers are requiring, as we said, only receipts, and it's likely going to be more costly for the employer because the benefit is broader in scope, and that's usually dead on arrival when that happens in a boardroom. But employers could run the risk that a payroll reimbursement of this kind could qualify as setting up a new medical plan and thereby raising compliance and other related issues. So even if they want to do it, it's not a flip of the switch. So what happens if an employer decides to offer additional benefits? Are there any tax considerations to keep in mind? Well, yes. As we've noted before, reimbursements for certain travel and lodging can be considered medical care and therefore excluded from the employee's gross income under the federal tax laws. But there are, however, specific limitations under IRS, and that goes to what we've already talked about, the 22 cents a mile, the $100 or $50 per person for lodging per day. And any amounts reimbursed under the plan over those limits will be taxable to the employee as income, but should not result in any negative consequences, tax consequences under the plan. And reimbursements for meals or other personal expenses are not considered medical care under IRS rules and generally cannot be provided to the employee on a tax-free basis. But if you limit additional benefits only to abortion services, so what happens if, we did just that? Well, any employer, seeking to limit additional benefits to only abortion services should consider other legal requirements under ERISA applicable to its group health plan, because you might be putting that in danger. For example, there may be issues to address with the health discrimination rules under HIPAA and the minimum value and essential benefit rules under the ACA, and the parity rules for mental health and substance abuse benefits under federal law. So if you haven't figured it out yet, a lot of moving parts and no easy solutions. Additionally, an employer may also need to coordinate the additional benefits with its health savings accounts, health reimbursement accounts, flexible spending accounts, wellness programs, and other welfare plans offered to employees to ensure compliance with IRS rules and other legal requirements. Finally, there may be issues under state and federal employment laws that need to be addressed as well, which may promote or prohibit. So, what about CBAs and the obligation to negotiate? Well, I've never seen a contract with a union that didn't have what we call a zipper clause, which, and this language is very typical. If mandatory laws applicable to and in conflict with any of the provisions hereof become effective, the agreement shall be subject to revisions by the parties to bring the conflicting provision into conformance with the law. These actually started in World War I, when the government started to tell the unions and management with the war labor boards what they could and couldn't do. And some of that was against their contracts. So they put language like this in saying, okay, if the government tells us we have to do it, if the law changes, then our contract has to keep up with the law. And this includes negotiated benefits. It can also include non-negotiated benefits, as well as other conditions employees have come to consider part of the terms of employment. This is known as a past practice, and that can be negotiated as mandatory subjects of bargaining. So we're talking here wages, hours, working conditions, and that includes benefits. Now, if you have a union and you haven't started negotiating with them on these issues, all the ones that I've talked about and all the ones I'm going to talk about, you're behind the 8 ball. You should have been doing this yesterday at the latest, because there is no leeway in the laws, in the state laws, that say, well, we're just going to go ahead here as we have until the contract expires. No, you need to be making those changes now. And if you have some benefits that promote abortion, and you're in an anti-abortion state like Texas, you need to be stopping those, putting the skids on that immediately until you can figure out what you're going to do for bargaining and how you're going to do it. Also, protected activity. Workplace speech about abortion. Employers must also be aware that certain speech in the workplace, including speech about abortion, may be legally protected, and you don't need to have a union. You know, the National Labor Relations Act, in a few places says the union, but in most it just says the employer and the employees. So if you have no union, but you have 2 employees, more than one, who go up to their employer and say, we'd like a raise, and the employer fires them. This actually happened in the Midwest many years ago. He violated the National Labor Relations Act because they were acting in concert. They weren't representing everybody. They were just representing themselves. So with regard to free speech in the workplace, you could be violating it. Now, although the First Amendment generally does not extend to private companies, so if you're public sector, be aware of the First Amendment. The National Labor Relations Act prohibits retaliation against employees who discuss the terms and conditions of employment, commonly referred to as protected concerted activity. Now, therefore, employees, 1, discussing or advocating for an employer to provide benefits to women seeking reproductive and abortion-related healthcare services. I would throw men also for their wives or partners. Or 2, advocating for the employer to take a certain public stance on the issue. Or 3, protecting the employer's public position on the issue may constitute protected speech under the National Labor Relations Act, depending upon the circumstances, and not to interfere with the business, because that is a condition under the NLRA, and therefore prohibits either direct or indirect retaliation. The other thing that may come into play here are whistleblower laws, but that can go either way depending upon the context of what's the whistle's being blown on. So what about union or other supplemental health plans? Because when I was a dues-paying member, like the last 15 years, I could opt into a supplemental health plan. So when my employer, as my primary insurance, covered something, but I had my copay, I could then submit the copay to my union insurance if I wanted to. And professional organizations also offer supplemental insurance, and so do social organizations. So although the last 2 are not employers, and in fact all 3 are not employers, such plans may also be subject to the same prohibitions and freedoms as the employer plan regarding abortion coverage. And not all your employees or people who work may have all of these. So each case may be a little bit different. So we've talked a lot about travel and traveling to where abortion is legal. And, as this slide notes, some of the travel reimbursement plans employers have begun to implement or consider in the wake of Dobbs. This will be the final word on travel for those of you who've said, what, again? But many businesses in states where access to abortion will be prohibited or highly restricted are considering or have already implemented benefit or employer expense plan amendments that would cover travel and lodging for out-of-state abortions. Ultimately, the legal and regulatory future of such plans remains unclear, especially in states where abortion laws are the most restrictive and contain the aiding and abetting clauses or liability. But there's some good news here. Employers seeking to enact such benefit or expense plans may find some comfort in a statement contained in Justice Kavanaugh's concurrence in Dobbs, specifically when he wrote, and I'm quoting, "Some of the other abortion-related legal questions raised by today's decision are not especially difficult as a constitutional matter. For example, may a state bar a resident of that state from traveling to another state to obtain an abortion? In my view, the answer is no, based on the constitutional right to interstate travel." This is where I fail to be objective. I would add, at least for now. So it appears that outright travel bans or similar prohibitive restrictions would face significant legal challenges and could be declared void. At this early stage in the post-Roe era, there appears to be several paths emerging for employers seeking to provide travel benefits. Each comes with its own set of potential issues and considerations that employers, in conjunction with their counsel and benefit providers, should evaluate carefully. We keep going back to that. I know it's like a mantra at this point, but it can't be said too often. So, just when you thought we talked about all of it, payroll charitable contributions. A lot of employers have these. The employees can take a part of their paycheck and donate it to some charitable contribution, or to many of them. And these, many employers have auto payroll charitable contribution deductions. Think food banks, shelters for abuse victims, United Way. Some provide a limited choice. Other employers have input from the employees in the union as to which ones they're going to use. Some allow for individual employee selection, and some are a hybrid. However, some organizations, and think Planned Parenthood here, may no longer be prudent or acceptable for the employer to promote contributions, especially if the employer is making a matching contribution. So if you think geographically, professionally, and culturally in terms of a community, this may create a change in thought, which may need to be discussed, negotiated with employees, or this is one of those things, if you have it in your contract, or it's not in the contract, but just something that's been happening, so it's considered a past practice, you need to be at the bargaining table talking about this before, and any changes before it becomes policy. Immigration status. So employers are also well advised to watch for state laws imposing criminal penalties on residents who receive abortion services, whether in state or in a place where abortion is legal. If a non-U.S. citizen receives abortion services, such state laws could potentially jeopardize the employee's immigration status and correspondingly their authorization to work in the U.S. Any such laws may deter non-U.S. citizens from seeking employment in these states, particularly when the employment requires a long-term contract or commitment or a lengthy green card sponsorship process. Questions further arise as to how the decision will affect a non-U.S. healthcare professional who provides abortion services and whether their immigration status could be impacted. And now we get to the good stuff. I save the good stuff for last. The elephant in the room, religion. According to the Pew Research Center, some religious groups, including the Roman Catholic Church, Assemblies of God, Church of Jesus Christ of Latter-day Saints, and the Southern Baptist Convention, oppose abortion rights with few to no exceptions. While, on the other hand, the Episcopal Church, the Evangelical Lutheran Church in America, and the United Methodist Church support abortion rights with some limits. Conservative and Reform Judaism and Presbyterian Church, Unitarian Universalist, and the United Church of Christ support abortion rights with few or no limits. So again, according to Pew, Islam, Buddhism, and National Baptist Convention and Orthodox Judaism hold no clear position on the procedure. So there's a case in Indiana where 5 anonymous women who are Jewish, Muslim, and spiritual, along with the advocacy group Hoosier Jews for Choice, argued the state's ban infringes on their beliefs, and the ban imposes Christian values and ideologies upon them at the sacrifice of their own beliefs. What's distinct about the latest suit by 3 Jewish women in Kentucky is that all 3 require IVF, or in vitro fertilization, to become pregnant, but they're afraid of beginning the procedure without greater clarity on what the law permits with excess frozen embryos. The women must spend exorbitant fees. Excuse me, I have to take my notes and put them down because I'm losing the light here. The women must expend exorbitant fees to keep the embryos frozen indefinitely. And they're unsure if they will face felony charges if they dispose of them. This is because the law is unclear regarding the experiences of potential birth givers with regard to their access to reproductive technology. Now, this is where things start to stretch out, and by my observation, now we're getting into people who aren't pregnant, but people who want to be or could be or want to prevent being pregnant. In this sense, the Kentucky suit's about women who want to give birth, not women who want to abort. And yet Dobbs is impacting them. Berg Raunick, she is a member of Hoosier Jews for Choice, but not involved in the lawsuit, states, quote, "This has to mean protecting all religions, not just Christianity, and not just the majority. Now we sort of wait and see how true that is." So keep your eye on these and unrelated cases. One or more about to show up at the Supreme Court. And this is just Bob speaking. That's when we're going to know if we're living in a democracy or a theocracy. Although some people see Dobbs as declaring that already. So what are the next steps? What should your company consider for next steps? Well, employment law issues will continue to arise and evolve in the coming months and years, I would say. Following the Dobbs decision, the EEOC, DOL, and HHS may provide further guidance on how Dobbs impacts employment laws, such as the Family and Medical Leave Act, FMLA, Americans with Disabilities Act, PDA, like we've discussed. So, what should the next steps be? At this point, there's still too many unknowns, regarding how current state abortion laws will be enforced and whether new laws will be enacted in the future. As a result, employers who want to offer additional benefits to facilitate abortion access for their employees should discuss the options and risks with their legal counselors. Now, there is some proposed federal legislation out there. This is according to the Economic Policy Institute. You've got the Women's Health Protection Act, which protects women to access abortion care throughout the U.S. Don't know what's going to happen with that. Equal access to abortion coverage and health insurance, which is going to ensure abortion coverage to those receiving health insurance through the federal government. So that would be all federal employees, maybe vets and other folks, and the right of health insurance companies to offer abortion coverage. Just this evening or today, about 2 o'clock, the AP put out a headline saying that this is going to be the key issue in the 2024 presidential election. Not these pieces of legislation, but Dobbs. Now, there's also some ancillary proposed federal legislation. These additional congressional acts would support working people who are the most negatively impacted by abortion bans and restrictions, but they don't go directly to abortion. But there they are for what they're worth.